does it be extinguished? Now, family property will be lost where, for instance, the property is partitioned. That is where family members share the property among themselves. Then we say that is the end of the family property. Secondly, if it is sold, then of course that is the end of that family property. It can be sold to a member of the family or to any member of the outside who are not members of the family. Now, what are the rights of a family member in family property? One, he has the right to a portion of the family land for use by himself. He has the right to, he has the right to consultation on matters affecting family land. He has the right to share income and benefits arising from the family property. And also he has the right to have family head renders account of the management of the family property to him. Those are the rights which every member of the family has in family property. Now, supposing the right of a member is breached, a member of the family, we have just mentioned the rights he has over family property. Supposing those rights are not allowed to him, what are his remedies for the breach of the rights? One, of course, he can call for partitioning of the land, which means everybody should have his own portion, and that family land will cease to be family property. And then you can ask for sale of the property so that the proceeds can be shared, or you can ask for an injunction from the court to ask the court to stop the breach which is occurring. Now, I will pause a bit here. I've mentioned partitioning and so many times. Now, we'll just quickly look at the difference between what we call partitioning and allocation. I've mentioned allocation of family property too. Now, there are two ways by which family property can be disposed of. Well, can be managed. Either sometimes you allocate or you partition. Now, when you allocate, you are giving a member of the family a certain right to the property, but that property does not belong to him. He has only use rights or occupational rights over the land. So for no matter how long he used that land will still revert back to the family. But when you have partitioning, it means the property has been divided among the members, so that after that partitioning, each member becomes the owner of that part given to him, and that land ceases to be family property. Now, I mentioned also that family property can be sold, alienated. Alienated. Family property can be alienated. Either you sell it or transfer it to another person and so on. Now, how is that done? Before a family property can be properly alienated, it has to be done by the head of the family in consultation with principal members of the family. Now, what then happens if a head of the family, for instance, decides to sell family property without the knowledge of the principal members of the family? Alternatively, where principal members of the family decide to sell family property without the consent or knowledge of the family head. Or the third scenario, let's suppose the family head sells or attempts to sell family property as its own, of course, without the consultation with the other members of the family. What happens to that transaction? I'm repeating the three. One, a situation where the family head alienates, that's either transfer, mortgage, or sell family property without the consent of members of the family, the principal members of the family. Alternatively, the second scenario is where members of the family, principal members of the family, sell property without resort to the head of the family. And thirdly, where the head of the family sells family property as if it is his own. Of course, in that kind of case, you won't have consultation with the members of the family. So in the first scenario, where the head of the family sells family property without consultation with the principal members of the family, that transaction is void. But if the members of the family now sell property without the consent of the head of the family, the transaction we say is, sorry, I'm sorry, I mixed it up. Let me repeat, I'm sorry. Now, when the head of the family sells property, family property, without consultation with the principal members of the family, that transaction is voidable. It is very important, I'm sorry. It is voidable, not void. Please, did you get that correction? Hello?
Yes,
Hello?
sir. Yes, sir. We got it.
Aha. Let me repeat it. It's very important so that you don't mix it up. When the head of the family sells family property without consultation with principal members of the family, that transaction is voidable. When members of the family now sells property without the consent of the head of the family, the transaction is void. The third one, where members of the family, where the head of the family sells family land as if it is his own. It's not selling it as the head of the family, it's selling it as individual owner. That transaction also is void. Now, please, can you respond back if you understand the implication of if it is void and voidable before we move on?
Yes, sir. So voidable is they can void it or not. But if it's void, that means it's absolute. It's void.
Void is incurably bad. There's nothing they can do to you see. You understand? It's incurably bad. So that in the first example where we say it is voidable, the non-consenting members, for instance, who were not consulted, can later agree to the transaction. I hope you understand. That is in situation where it is voidable. But where we say it is void, there's nothing you can do to correct this thing. Let me give you a practical example. For instance, the head of the family sell family land without one person, they have maybe 3 principal members of the family. He sold and told 2 of them. The third one maybe was not around or not consulted. They collected 1 million naira. We say that transaction is voidable, which means it can still be amended, but until it's amended, it is void. Let's say the third person now comes and they give him his money, now say he accepts, then that transaction becomes good. But let's suppose it's the members of the family that sold without the head of the family. We say that transaction is void. Even later, the head of the family comes and says, I agree, that transaction is still void. I hope I make the point. Now, let's look at, draw your mind back a bit. When I was talking about land tenure system, I said there is customary land tenure system and non-customary land tenure system. Under customary land tenure system, we say that is land tenure under customary law, as known in Nigeria. Then we have the non-customary land tenure system. Sometimes it is referred to as land tenure system under received English law. That is land tenure system as brought about by the British when they were coming. Now, under the non-customary land tenure system, the first thing you should note, that's under English law, is that the concept of ownership, land is not regarded as owned by anybody. Land is not capable of ownership as we know it under customary land tenure system. What you have, the interest you may have in a land is referred to as an estate. So the interest a person has in land is referred to as an estate. And there are 2 types of estate. The first one is estate of freehold and estate less than freehold. Estate of freehold and estate less than freehold. Under estate of freehold, you have a fee simple estate and the fee tail estate. Under the estate of freehold, you have fee simple estate and fee tail. Now, fee simple is probably the nearest you have under English law to what we call absolute ownership, in the sense that it's the highest level of interest a person can have under English law. And it can continue forever, in the sense that as long as there's somebody who is inheriting the original owner of the fee simple, that property will continue devolving back, falling down to his heirs, his descendants forever, as long as somebody who is along the line of descendants to him. So it can continue forever. There is no determinable time. Now, the other one is the fee tail. Sorry, before I move on. Usually, when you want to convey property land to somebody in fee simple, the best is I give this property to pay some so and so in fee simple. But sometimes when you just say I give this property to Mr. A, that will show fee simple. Now the second one is fee tail. Now in fee tail, it is also an estate of inheritance in the sense that it can pass from one person, one generation to another, just like the fee simple. But the difference between it and the fee simple is that the fee tail can only be if a person has an estate which is described as fee tail, it means that it can only be inherited by his direct descendants. So that as long as he has a direct heir, that property will continue going down in his family. But the moment there is no direct descendants, that property will revert back to the original grantor. So that if, for instance, they say, I give this property to Mr. A and the male is male descendants, which means as long as Mr. A has a direct male descendant, that property will continue falling down onto his male descendants until, but the moment there is no male descendants, and that's a failure of descendants, then that property will revert back to the original grantor. Now you have estate which is other than freehold. That is, it is not free. You see, because the first one I said is estate of freehold. That means there is no encumbrance on your hold. The only thing is differentiated between fee simple and fee tail in terms of how it can be inherited down the line of your descendants. But in estate other than freehold, that is not a freehold, as you said. It, as its name applies, it is an estate which is tenurial, that is, which has a date. Unlike the first two, you cannot say today, if I give you an estate of freehold, it will extinguish in 20 or 200 years. But for estate of freehold, there is a terminal date. It is what we know, what is now called leases, in the sense that it has a terminal date, either fixed or which is determinable in the future. Now, as I mentioned also, just a moment, I'm trying to stop. I'm not being able to stop. As I mentioned earlier, when you are talking about land use, when you are talking about land tenure system in Nigeria, apart from the customary and non-customary land tenure system, you have to have the Land Use Act, because that is the principal act now that regulates land use in Nigeria. Now we will pause briefly to now look at the Land Use Act, just briefly, so that we move on. Now, the Land Use Act was an act which was enacted in 1978, and it has a reason. Why was the Land Use Act enacted? Why did the government feel that the Land Use Act is necessary? There are a lot of reasons, but the most important of them is that, or let's put it this way, before the Land Use Act, there was this problem confronting this nation. You have people, land speculators. That is, people who do not need land for any productive use. They just want to buy it and keep it there until the price rises, and then they will sell. They have people communities and people who refuse government land when government needs it. You have situations where industrialists, people who really want to use land, they get there, they cannot use the land because they have scrabbles of I'm the owner, I'm not the owner. So the main reason for the enactment of the act are as follows. Now, there is a need for the government to acquire land for developmental and infrastructural purposes. They wanted the government to be able to freely acquire land for developmental and infrastructural purposes. Then secondly, the need to curb land speculators. Then the need to allow persons who have a genuine use of the land to have access to the land. And finally, the need to reduce the cost of acquiring land. Let me quickly go through the four. One, there's a need for government to be able to acquire land for developmental and infrastructural purposes. Now, in the past, so that, okay, secondly, there's a need to curb land speculators to prevent land speculation so that people who are, and then thirdly, there's a need to have to enable people who need land genuinely to have access to them. And then fourthly, there was a need to reduce the cost of acquiring land. Now, there are a number of provisions in the Land Use Act which attempts to achieve these purposes, but we will not go into that. Now, the Land Use Act, one of the basic things the Land Use Act did was that Section 1 of the Act, for instance, in pursuant of this objective, the Act confers on the governor ownership of the land in each state. It vests the land in each state of the federation on the governor of that state to hold in trust for the people. The Act provides, as I said, Section 1, let me quote, subject to provision of this Act, all land comprised in the territory of each state in the federation are vested in the governor of that state, and such land shall be held in trust and administration for the use and common benefit of Nigerians. So that now the governor is the prospective owner of all land in the state. Of course, the land in the Federal Capital Territory are outside the purview of the Act. That is, land belonging to the federal government or land within the Federal Capital Territory are outside the provisions of the Act. Now, the system of land holding introduced by the Land Use Act divides land into two, land in a state into two. You have the urban land and the non-urban land. The urban land, the management and control of urban land is vested in the governor of that state. The governor of the state has the control and management of land in urban land, while land in non-urban land, the management and control is vested in the local government authority. Of course, what determines whether a land is urban or non-urban is the governor. So urban land is all land that is designated by the governor as urban land. Just like, for instance, in Lagos, all land in Lagos is regarded as urban land. But there are some states where the land, part of the land is urban, part is non-urban. As I said, the local government authorities have the now. For the urban land, the Land Use Act created what we call the Land Use Allocation Committee, which assists the governor in the management and control of land in urban area. Whereas in the local government, they have the Land Allocation Advisory Committee, which helps the local government authorities in the management and control of land which is non-urban land. Now, another thing about the Land Use Act is that it converts any interest in land into a right of occupancy. All interest in land which a person may have in land after the Land Use Act is converted to a right of occupancy. That means a right which you have to occupy the property, the land, not ownership. And there are two types of right of occupancy. You have the statutory right of occupancy and the customary right of occupancy. The statutory right of occupancy is the right of occupancy which is granted by the governor, while the customary right of occupancy is the right of occupancy which is granted by the local government. Now, there are one or two other things which I will say before I go back there. Now, one of the questions that arose is what happened to people who had land before the Land Use Act? So, and I told you that all rights of occupancy, all right under land is converted to right of occupancy. So what the act provided for was that anybody who had land before the Land Use Act, who is entitled to ownership of the land before the Land Use Act, is deemed to have been granted a right of occupancy over the land. So that sometimes we distinguish between deemed grant and actual grant. Actual grant is the right of occupancy which is granted after the Land Use Act, which is granted by either the local government or the governor. But a deemed grant is an assumed grant that applies to people who have control and who have the right to use land before the Land Use Act, who are now considered to have been granted that right by the governor. Now, another document which the Land Use Act introduced is what we call the certificate of occupancy. That is just a document which evidences a right of occupancy. It is the evidence of the fact that a person has a right of occupancy. Now, alienation of right of occupancy. The right of occupancy generally, just like any other article of ownership, can be alienated, can be sold or transferred anyhow by the owner. But the Land Use Act requires that anybody who is going to alienate the right of occupancy must obtain the prior consent of the governor before such alienation takes place. And alienation includes the assignment, as I said, mortgage, transfer of possession, sublease, or whatever. A person who alienates without obtaining the consent of the governor will have committed an illegality and it is unlawful. And as you will see later, it might be one of the it's a ground for which the governor may revoke the right of occupancy. Now, if, like I was saying shortly, if the owner of the right of occupancy alienates the property right without the consent of the governor, there are a few consequences. One, as I said earlier, the act empowers the governor to revoke the right of occupancy of that person over the land. And then, secondly, as that transaction is a nullity, and then thirdly, it's also illegal. So those three consequences will. Now, when does the right of occupancy extinguish? There are certain things which will extinguish the right of occupancy. Now, there are about 4 of them here. We have exclusion of time. Now, if the right of occupancy was granted for a particular time, the most common we have in Nigeria is 99 years. But we have a right of occupancy which was granted less than 99 years. In that case, if the right of occupancy was granted for a particular time, at the time the time expires, that right of occupancy also expires. And then a person will have to renew if he wants to continue. But just a brief digression. You see, the question sometimes comes up whether a deemed right of occupancy, a deemed grant of the right of occupancy is subject to number of years. Because in an express grant, the governor will stipulate the number of years. But you find out that in a deemed grant, there is no actual grant. So there is no opportunity of the governor to state the number of years which is being granted. So there is controversy whether a deemed grant will also expire after some time. But what is important is that if the right of occupancy is expressly granted, it will expire at the time after the time period. Then secondly, of course, the right of occupancy will expire when it is surrendered. A person who has the right of occupancy over a property may surrender it to the government. And then thirdly, forfeiture. As you will see later, there are certain circumstances where a person may forfeit his right of occupancy. For example, if the person fails to pay rent, ground rent on it, the government may forfeit the right of occupancy. And finally, also, the right of occupancy may be revoked by the government. Now, on the issue of revocation, the Land Use Act provides certain circumstances. Just a moment. The right of occupancy, sorry, the Land Use Act provides certain circumstances which will lead to revocation of the right of occupancy. Generally, it is when there are three broad reasons why the right of occupancy may be revoked by the government. The first one is where the land is required for overriding public purpose. And there's a list of what the Act considers as overriding public purpose. They want it for roads and things like that, or parks or government projects, is overriding purposes. Then secondly, where the land is required by the federal government. And then thirdly, where the owner of the right of occupancy has breached any provisions of the Land Use Act, then the government can revoke the right of occupancy. Now, however, in revoking the right of occupancy, the law requires that certain steps must be taken. In the first place, revocation must be a genuine revocation. That is, there must not be revocation with the idea, for instance, when the government is revoking the right of occupancy only because you want to transfer it to somebody else. That would not be a proper revocation, and the court will nullify it. For instance, land is revoked by the government for overriding purpose, and the second day they are not using it again, they now sold it to somebody else. That will be regarded as not revocation for overriding public interest. Now, revocation also must be done by the person who is empowered to revoke. That is usually the governor or the person the governor authorized, especially authorized to do the revocation. There has been cases where a commissioner of lands who is not empowered by the government specifically signs a revocation letter. The court has notified that kind of revocation. Secondly, there must be notice issued stating the purpose of the revocation, and the notice of revocation must be served on the holder of the land. So those conditions must be met. It must be a proper revocation. Revocation must be done by the person who is empowered to do so, usually the governor or somebody who is empowered by the governor. Then thirdly, notice must be issued for the notice must be issued which states the purpose of the revocation. And then finally, the notice of intention to revoke the right of occupancy must be served on the owner of the property. You just give me 5 minutes. I will come back there. I want to power my laptop. Listen, just a moment. I'll be back now. Gloria, come and put on the generator fast. Gloria, just a moment. I can change it. I can change it now. Now, all the other things, all some things. Okay, sir. Sorry, I'm back. I'm sorry. Um, as I was trying to say, before the revocation is considered proper, that it must be done by it must be a proper revocation. 2, it must have been done by the person who is authorized to do it. And then thirdly, there must be a notice stating the purpose of the revocation, and also the notice of the intention to revoke must be given to the holder of the right of occupancy. That will allow him to put in a defense or something if he wants to. Now, the next thing is the issue of compensation. Both under the Act and under the Constitution, no person's property, land in this case, can be acquired without payment of adequate compensation. So the Act provides for payment of compensation for land which has been acquired. Now, there is, apart from payment of money, there is a provision for alternative accommodation. If what is acquired is property which is developed and which has a building, the government may give the owner of the land the option of getting another house somewhere else in lieu of that, in lieu of payment of compensation. I will pause here a bit. I want to go to a small topic, declaration of title to land. I will want to hear questions if you have and observations.
Sorry, sir.
I'm waiting. Yeah.
The compensation, is it at current market value or what the government deems as the amount of money they want to pay?
You see, there are two, we'll answer this from two perspectives. Now, in the first place, the compensation is for unexhausted improvements. I hope you'll get that clear. It's not being paid for the land. The government doesn't pay for bare land. I hope you understand.
Okay, so it's for the building, what you built on it.
Pardon?
Yes. What you built on the land.
Yeah, something. Well, not, I don't want to use the word build because the word is unexhausted improvement. It doesn't have to be built alone. Maybe cassava is planted there or whatever. But let's just say whatever improvement you made on the land, which includes the building.
Okay.
So that technically speaking, if a person has only bare land, he's not really entitled to compensation in the real sense of the word under the Land Use Act, except maybe they will return to him the value of the ground rent which he has paid, which has not been used. I hope you understand what I'm saying for that part. Do you follow me, sir?
Yes.
Yes, sir. Yes, sir.
Hi. And then in respect of the main question you asked, whether it is current market value, I don't know, but I don't think so, because the compensation is determined by the Land Use and Allocation Committee in the ministry. I hope you understand. So they have their own value, but I don't know whether they will use current value. I don't know.
Yes, sir.
You understand, please? Is it the government that is not, government will fix the price? Maybe there will be some formula which they use to arrive at the value, but they will certainly not use current market value as known by all of us. I hope you get what I'm saying. Is that clear, sir?
Yes, sir.
So any other question? Is there only one person in the house?
No, sir.
Okay. Okay.
Hello, sir.
Yes, ma'am.
Yes, I've sent it to the chat that
Sorry, on here.
Pardon?
Recap. I need a recap on this grant, natural grant.
This grant and actual grant, okay. Now, I said that all interest in land I'm lost again. Anyway, are you listening? Are you hearing me? Hello?
Yes, now, sir. Yes.
I said that all interest in land has been converted to a right of occupancy, so that after the Land Use Act came into existence, anybody who wants to take any interest in land will apply for a grant of the right of occupancy by the government. That is an express grant. It's a grant of right of occupancy which was applied for after the Land Use Act. But you agree that before the Land Use Act, there were certain people who had interest in land. They own land. Now, the Land Use Act did not come to abolish their interests. What the Land Use Act does is to convert that right of occupancy, which that interest they have into a right of occupancy. But that right of occupancy, in order to distinguish it from those who apply to the government directly, is called a deemed grant. They are there because it is deemed or it is assumed that the government has granted them a right of occupancy. Now, for developed property, anybody who has a maximum of an hectare can ask for the government and can apply for a certificate of occupancy, and it will be deemed to have been granted to him while he's there. I don't know whether you get the difference now between the deemed and the actual. Madam.
Yes,
Madam,
sir.
you have a follow-up question?
No, sir. I said yes, sir. Thank you, sir.
Oh, okay. Yeah, the language is
Hello, sir.
Yes, ma'am. Oh, sir.
Sir, please, what's the basis for the calculation for the land use charge?
Ready?
The basis for calculation for land use charge, the charge that is given to a property on a yearly basis.
I don't get it. The only thing I had was land use charge, Joe. The line is breaking.
The basis for calculation for land use charge, the one given to property on a yearly basis by Lagos government.
I don't want to.
Can you hear me, sir?
What she's asking is the basis, how the government came about the calculation for land use charge that is given annually to Lagos State residents or owners of property.
Okay. Unfortunately, I have to disappoint you here. It's more of a matter of estate people than law. I don't know. You understand what I'm saying? But I won't be able to tell you the base. I won't be able to tell you the base of the calculation. The estate valuation people will be able, if you have a course on.
Okay, sir.
We are in law class, so no valuation class.
So I won't be. We will just be able to tell you the legal aspect of it, not the valuation aspect. If you follow. I'm sorry to disappoint you in that small area. Yes, you like go on now.
Yes, sir.
I was trying to look at sometimes issues come up when there's dispute as to ownership of land. Somebody now goes to court and asks the court to declare him the owner of the land. We said that he's asking for declaration of title to land. Title and ownership, I hope you know, is the same. So what are those things, or what are those ways by which a person can prove that he is entitled to ownership of land? How can they prove that he is the owner of the land? I hope you get the base of what I'm trying to say. Somebody says, I'm the owner of the land. He now sues somebody else. What are the means of proving the ownership of land? There is this very old case. I don't know if I was, what's the name again? Where the court laid down 5 grounds, acceptable grounds by which you can show that you are the owner of the land. And before I go on, I hope you know that in law we say that he who asserts must prove. That is, it is the person who is saying that he is the owner of the land who has a burden to prove that he is the owner of the land, not the other way around. So that if I'm trying to sue to court for encroaching on my land, it is my duty to prove how I am the owner of the land. So there are 5 ways, as I said, that has been recognized as means of proving ownership of land. You have by traditional evidence. I will go back to them briefly. You have by traditional evidence. You have by the document of title. You have by act of ownership. Then you have act of long possession, and then you have possession of connected land. That means when you are proving ownership of land, one, you might prove it through direct traditional evidence. That is when you are saying you are tracing your ownership from the origin of the ownership, the first owner of the property, who is the so you call oral evidence, you call traditional chiefs and so on to show that that land, you trace the ownership from the oldest person who the first person who owned the land up to your own ownership. You show who founded the land, the mode of the acquisition of the land, and the history of how the land moved from one person to the other up to the time it go to your own ownership. The second one is, which is a bit clearer, is by document of title. If you have documents to show ownership, those documents you can present it to the court. But those documents have to be genuine, then they have to have been processed the proper way. As you may see later, for instance, it has to be properly stamped, maybe registered if need be, and so on. So those are things which you have to do. Then you can also prove ownership, of course, by act of ownership. That means you can show that you have been exercising right of ownership over that land for a very long time without being challenged by anybody. That is also a means of proving ownership. It's not maybe the best method of proving, but that is one of the ways by which you can prove. And then also there is also, which is fairly similar to that, where you can show that you have exercised act of long possession and enjoyment of the land. Maybe you have been the person who has been putting somebody there to build houses there or to farm there, and you have been collecting rents for so long. Those are acts of ownership and possession. And then finally, if you can show that you this is not a very sound way, but it is still acceptable. If you can show that you are in possession or you are the owner of connected land. Let me explain a bit. You see, sometimes when you have two lands, and let's say A and B, and A is not in dispute that you are the owner, but B is the one you are trying to prove ownership now. If you can show that there is the link between, there is such a link between the two parcels of land that whoever owns one is likely to be the person who owns the other one, then that is also a method of proving ownership of B. Let me repeat. If you have two, as I said, it's not the best form of proof, but it's also acceptable. You have A and B land. They are so connected in such a way that whoever owns one is likely to be the person who owns the other one. Now, you are able to prove that you are the owner of A, but you are not yet able to prove that you are the owner of B. You are trying to prove the ownership of B. Now, if you can show that the two lands are so connected that whoever owns A is most likely to be the owner of B, and you are able to show that you are the one who owns A by any of the other evidence, then it means the court will accept, unless the contrary is proved, that you are the owner of B. I will pause a bit and ask whether this point is a bit taken. Hello?
You
Hello?
can go ahead, sir. We understand, sir.
Okay. I'm sorry, I'm perfecting, maybe my kid is not around to show me some of these things. I'm sure by the next lecture, I'll be able to look and then still be sharing the screen. But I'm not able to do the two together now. Now, sometimes also, if a person now sues for declaration of title to land, that person is a plaintiff. Sometimes there are certain defenses which a defendant may raise. When we say that somebody raised a defense, he's saying that, look, I know maybe I've done something wrong, but I should not be made to suffer for it because of certain reasons. If, let me use an example outside landlord before I return to it. If, for instance, now you sue me to court for slapping you, of course, there are two options. I may raise a denial. I'll say I did not slap you. I may, on the other hand, raise a defense. In that case, when I'm raising a defense, I'm saying, yes, I agree I slap you, but I have a reason why I should not be punished for slapping you. Maybe I say I'm trying to kill a mosquito in your cheek, or that you slap me first, or that I'm trying to defend myself, things like that. I hope you understand the decision. So when somebody is raising a defense, for declaration of title, when he is sued for ownership of, you can raise certain defenses. One of the most common defenses is what they call limitation of action. You see, in law, you cannot maintain you cannot, there's a limit to which, after which you cannot sue somebody for doing something wrong. There's a time limit. In this case, for land, generally it's between 12 and 12 years. So if a person is sued after the 12 years, he can come up and say, look, even if that land is his own, he has wasted time. This action is statute bad. This action has been, the limitation period has passed. You cannot sue again after a certain period. The same thing in other areas of law. If I owe you money, which is payable today, you cannot wait for 20 or 30 years time before you now sue me for the money. Because the time ahead, so it's 12 years, sometimes 6 years, depending. I'm not teaching that now. So if you sue me for court, I can say, look, even if I owe you money, the time which you should have sued has passed. And so there's a limitation placed by law on your action. The same thing with declaration of title. If you are suing the government institution, it's 20 years. If you are suing an individual, it is 12 years. After the 12 years, when the cause of action arises and you do not sue, then the person will come up with the defense that your action is statute bad. That is, the limitation period has passed. You have wasted time before coming to sue. Then the second one is, of course, which is clear, better title. If somebody is suing for ownership of land and you are able to show a better title, then of course that person cannot succeed. There was a case, for instance, where two people were given a letter of allocation for a parcel of land from the government. Of course, both of them had their new papers. But when one was sued by the other, the one who had the older letter was able to prove that he has better title because the government has given him that before they gave the other person. So there's a kind of showing better title. Then you have laches and acquiescence. That is, we can say that that person has the person who is suing for the declaration of title of land has sometimes wasted time, or he contributed to the mistake of the person. That is why, if you know that this is your land and you watch me while I mistakenly continue to build on it thinking it was my own land, the law will not allow you, after I finish building, for you now to sue me and say that it is your land. Once I'm able to prove that you stood by while I was making that mistake, then the law will not allow you to use it as an engine of fraud to claim the land. Now, there is also this issue of concurrent ownership of land. Concurrent ownership of land, where we have we talk about joint tenancy and co-tenancy. Yeah.
Hello, sir. Please, can you go
I'm
over
listening,
to, can you recap that limitation of action again, please?
Limitation of action. Okay.
Yes, sir.
I said that, okay, maybe in your mind, just leave land law. Let me use contracts or something else. Then I will come back to land law. Now, usually the question is, if somebody does something wrong to you, is there a time limit for which you can sue him, or can you wait forever? If I owe you money now and it's payable today, or I smash your car now, can you wait for 50 years before you sue me? What the law is saying is that there must be a time when a person should be free in his mind, that he cannot be sued over something else. You cannot have the sword of litigation dangling on the head of somebody forever. There must be a time when his mind should be free of litigation. That is what we call the limitation period. There are certain time after which you cannot sue for a wrong done to you. If you sue, we say that action is time barred, BARRED. Time has put a barrier between you and that action. We said the period after which you cannot sue is called the limitation period. So if you sue somebody, we say that the limitation period has passed, or that this action is statute bad. Law has put a barrier. It is not the issue that at that time is not the issue of whether that person did what he did or not. What the person is saying, look, Even if I did it, you should have come earlier than now. So the same thing with declaration of title to land. When you are asking somebody when you want to sue for declaration of title to land, you must come within 12 years after you are aware of that infringement. If you do not sue within 12 years, when you sue the person will say, look, even if I'm not even talking about whether I'm the owner or not now, but even if I'm not the owner, you should have come earlier than now. What the person is saying is that the limitation period has passed. You are not allowed to take action against him again. I don't know whether it's a bit clear.
Yes, sir, it's clear. Thank you.
Yeah, sorry, sir. In addition to that, what if you were not able to come forward before the 12 years? Let's say the person was in prison.
No, okay. Let me also use another. Let me just also use another one before I answer your question. Now, if you bash my car, we say that there's a tort committed. I can sue you for tort. Limitation period for tort is, I think, it's 3 years. But supposing I was in prison, for instance, or I was hospitalized for all those periods, of course, I cannot sue you if I don't know you have committed a crime. You have committed a tort against me. So what we are saying is, of course, the limitation period of 12 years will not start running until you are aware of that encroachment on your rights. Okay. I hope you understand.
Okay, so you must be aware.
Let's suppose, and you have to, it cannot be for her. Let's suppose you are building on my land. I came to meet and say, look, my friend, this is my land, though. It means as at year 1, you have known. You now waited for 13 years before suing me. You cannot help. But if you don't know, and you sue within the period when you know, you understand? I hope it's clear now.
Yes, sir.
Yes, sir.
Hello? Okay. Any other question? I was talking about, I'm not sure now whether, how long will this lecture hold, continue? How long will it last?
2 to 4, 4 to 6.
Okay, I don't know whether we have to, I'm going to do 4 hours lecture at the stretch, but still, let's continue. I'm not whether 4 hours at this. I think I'm not sure whether we're going to do 4 hours at this stretch.
Your phone and your laptop are on together. That's why you're getting the feedback.
Yeah, I'm sorry. Okay. Let me see somewhere. Unfortunately, my problem is that it is my phone that I'm using for the hotspot for the laptop. And initially, I on the Zoom on my laptop, and I'm finally got to off it. That's my problem.
Mute the laptop. You can mute the laptop.
Not very. Let me put it somewhere very far. Or give me 2 minutes. Let's see whether I can off the.
Hello, sir. You can mute the laptop.
Just mute the laptop.
Yeah, I'm using the laptop. It's just that the only reason why I don't want to off the handset totally is because I'm using the handset hotspot to power the laptop. You understand my predicament?
Yes, mute one, sir. Mute.
Okay. Hello? Is it better now? Hello, are you hearing me now?
Yes, sir, it's better now.
It's a bit clear.
Let's move.
About the length of the class, you can take a break. You can put in a break whenever you choose.
Okay, maybe when I finish maybe another 10 minutes, I will take a break, and then that I will do to see what I have. I was talking about concurrent ownership of land. Hello? Hello?
Yes, sir. Perfect now, sir. It's very good now.
I was talking about concurrent ownership of land, where we talk about joint ownership and co-ownership. Now, do you know the difference between joint tenancy? Well, sometimes we call it joint tenancy and co-tenancy, or tenancy in common. What's the difference? Have you come about those terms before? Hmm? Hello? Hello?
Hello, sir. No, sir.
You see, when you have, because sometimes, for instance, your dad, for instance, leaves the property for you and your brother. The question will be, that's why the issue of joint tenancy and tenancy in common comes in. The question will be, do you have a distinguishable interest in it? Can you sell your own parts? Or, for instance, if one of the parties die, what happens to his interest in that asset? This question can only be answered if, depending on whether they are joint tenants or joint owners, or whether they are tenants in common. When you have joint tenancy or joint ownership, it means no party has a distinguishable part of the property. No party can have a distinguishable part of the property. For instance, the dad leaves the property, say, I leave it to my two sons, A and B. In that kind of case, there is a joint tenancy in the sense that none of them can say he has 10% or 50%, or you understand. In that case also, if one of them, there's what we call the rules of joint survivorship. If one dies, his own asset, his own part of it cannot be taken to his family or his dependents. The surviving tenant or the surviving owner will continue ownership. I don't know whether I get it clear. Let me repeat.
Yeah, repeat.
When you have a joint tenancy or joint ownership, it means that none of the parties have a distinguishable or severable, that can be separated, severable interest in that property. They own it together without any the boundary of which is this person's own, which is that person's own. The implication is this: if it's a joint tenancy, there is what we call rules of survivorship. If one of them dies, his own share cannot go to his family or dependents. The surviving partner will collect it as will continue the ownership. It's only when the surviving partner dies that it goes to his own estate. Now, one of the ways of doing it is if, for instance, the father leaves property and say, I leave it to my two sons, A and B. In that case, they are tenants in common. No distinguishing aspect. So if one of the son dies, his share of the asset will not go to his own children. It will remain with the survivor. Unlike when you have tenants in common, in that case, each person has a distinguishable aspect of the tenancy or the property, which you can mortgage, you can sell, you can do this. If, for instance, somebody leaves the property and say, I leave property to A and B to be shared equally, in that case, they have distinguishable interest in the property. So that if one of them dies now, his own half will go to his estate. So sometimes is the word used that, but if it is not clear, if the word does not show a clear cut demarcation, the court will assume that it is a joint tenancy. Is there a question on that, sir? It is important, especially because of a number of reasons. One, like I said earlier, if one of the partners die, if one of the owners die, whether his own dependents will have a taste of that asset will depend on whether he is a joint tenant or a tenant in common. I hope you understand. Secondly, if it's a joint tenancy, the other partner cannot sell his own interest because there is no distinguishable interest. He can only pledge whatever comes to him, but not the asset of the thing, because there is no separate interest. He has no separate interest which he can sell. He cannot say I have 10% or 5%. No. So the joint tenant cannot sell his own interest because there is no separate or distinguishable interest. Of course, if before I go on with that, do you understand the joint tenancy and tenancy in common?
Yeah, so basically, sir, it's about the will or the instructions
Yes, sir.
given by
Yeah,
the original owner.
yes, it depends. That's correct, but let me put it in another way. It goes to the root of the ownership. How did you come about it? That is where the thing will start from. I hope you understand. If, for instance, somebody, your dad who is not dead, does that fine or through the will, or sometimes you contribute money to buy a property. Usually, most of the time, if you contribute money, then it will be a tenancy in common. I hope you understand. But for instance, let me give you another example. Supposing both of you, I'm just is a very not a very apt example. Let me just give. Supposing there is a lottery. So you understand that you don't pay money for it. Maybe you just do numbers. You and your brother now we are just contributing numbers, and somehow you won a house. So you understand. Now, what is your share of that house? That may be a problem. So the court will have to decide whether you are joint tenants, joint owners, or owners in common. Because if you are not owners in common, then you cannot say I have an equal 50% share. I hope you understand. And then if it is not the owner in common, then if one party dies, his own share doesn't go to his dependents. Though in that kind of case, the court, usually both of you have contributed to end the house. They may say you are tenants in common because of equity. But I just give that as an example. So,
Yes, sir.
you know,
Understood.
equity is equality. When there is a doubt, the equity will always assume that there is equality. Now, of course, if you have a tenants in common, it doesn't mean that it may joint tenants. It doesn't mean that it will end in continue forever. The two of you, the parties, the owners of the party may decide to alienate, sell the property. They may decide to partition it, and that will end the joint tenancy. But until then, there is none of the party who has a distinguishable interest. So that, for instance, if he's owing money and the only asset he has is a joint owner with another person, they cannot come and sell half of the assets or come and take the asset to pay his debts. Do you understand? Because the joint tenancy, he has no distinguishable several, he has no separable interest in the property. Any other questions, sir?
No, sir. Thank you, sir.
I'll wait. I'll take another maybe 10 minutes. But you can 10 minutes. I will not shut down anything so that in 10 minutes I'll just come on there again. Is that okay, sir? Just 10
Yes,
minutes.
sir. Yes, sir. Thank you, sir.
This thing you're doing, why can't you just make one for my daughter? I can't do it. I need one by.